Article 7 talks about opinions, specifically opinions of both lay and expert witnesses. What is the difference between a lay witness and an expert witness? Don't raise your hand, it's creepy.
One is qualified to speak on technical information that you need a scientific basis to speak about, or the 700s lay the groundwork on what qualifies as that testimony, and the lay witness pretty much speaks on only what they have observed through their five senses.
Yeah, basically that's exactly it. Your answer basically embraces the distinction between Rule 701 and 702. 701 is opinion testimony by lay witnesses. Stop. Opinion testimony by lay witnesses. What rule that we just covered in the past 15 minutes does that remind you of? Wow, you guys have the attention span of a gerbil.
Lack of personal knowledge, 602? 603? No, 602.
That wasn't what I was thinking of, but that's actually a better answer than what I was thinking of. I was going to go with 608 because you can offer your opinion of someone's character, but you're very right. In order to gain personal knowledge under Rule 602, as a lay witness, you would to have had some opportunity to observe what it is that you're testifying to with one of your or many of your five senses. So the language of Rule 701 reads as follows. If the witness is not testifying as an expert, so if you're dealing with a lay witness, the witness's testimony in the form of opinion or inferences is limited to those opinions or inferences which are A, rationally based on the perception of the witness, comma, not or, not and, comma. B, helpful to a clear understanding of the witness's testimony or the determination of the facts and issue, and C, not based on scientific, technical, or other specialized knowledge within Rule 702, which means that in order for a lay witness to give his or her opinion, there are three requirements, each of which you must satisfy in order for you to in order to get that testimony in over objection. So let's break it down. First thing is the rational perception of the witness. And Mr. Garcia was so kind as to explain to us that when you're dealing with rational perceptions, it's the senses. See, sight, hear, feel,
Here.
Taste.
touch, taste.
Yeah.
Are there six senses?
There's 5.
There's 5. Taste.
Taste, hear, touch, smell.
Oh my god, this is retarded. See, sight, hear.
You said
touch.
see and sight.
Yes.
Oh!
See, smell, taste, hear,
Feel.
Feel.
touch.
Yeah, there you go. There you go. The
See,
fun-
sight, look, your eyes.
Okay, so if it's observable by your five senses, by one or all of your five senses, then it is within your rational perception. Key word here is rational perception. It is irrational. It is an irrational perception for for someone to testify that they could observe something that was half a mile away by sight. So that's a twist on this. In other words, if someone gives their opinion as to how fast they think a car was when it drove by them, sure, you can estimate how fast a car is driving, but if you didn't see that car until it was if it never actually drove past you and it just kind of went up the block half a mile away from you, you're not qualified to give that opinion because you're not close enough to give in order for you to have a rational perception of that. You guys see how that can be attacked on cross-examination? Or how you can just stand up and say, objection, improper opinion, ask to be heard, and explain yourself in that format. Your Honor, this is not a rational perception. No rational person could perceive the speed of a car when it's half a mile away. They're not close enough to make that observation. It's just that simple. It's really common sense. So we clear on the first requirement in order for a lay witness to give his or her opinion. We're good to go? All right. Helpful to a clear understanding of the witness's testimony or the determination of a fact and issue. This is a really low standard. Just about everything that a witness is going to testify to is going to be deemed to be helpful to a clear understanding of their testimony. What does the language in the second part of subsection B in 701 remind you of? The words "or determination of a fact and issue."
Has to be relevant.
Right. Exactly. That's exactly it. 701 imposes a quasi-relevance requirement on the opinion testimony of a witness. In other words, if no one cares how fast the car is going, it's not relevant. So it's objectionable under Rule 401, and it's also objectionable in terms of an improper opinion because their opinion is unnecessary to determine any fact and issue. And therefore, it also wouldn't be helpful to a clear understanding of the witness's testimony. Questions on that? All right. C. Not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. We're just going to move on to 702. Are we clear on 701? You have to have all three requirements. And don't let anyone get away with that. In other words, if it'll take a while for you guys to internalize these rules, but when you start putting them into practice, you should be able to recognize whether something is a proper lay opinion. Before we go on to 702, let's keep in mind that you don't necessarily, just because you're a lay witness testifying, not everything you say is an opinion. And just because it's a rational perception doesn't mean that you're giving an opinion. In other words, Rule 701 only speaks to the admissibility of a lay opinion. There's lay testimony that isn't a lay opinion. The witness's name, relationship to the events that happened, what he or she saw is not an opinion. It's only when you can put the words, "in my opinion," in front of whatever it is that they're saying, and it still makes sense, that it becomes an opinion. Are we clear on that distinction? Crystal clear on that distinction. Not just fuzzy clear, like crystal clear. Yeah? All right. 702, testimony by experts. If, the first word is a conditional word. That means if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue. The first clause, again, imposes a relevancy requirement on it. In other words, the expert testimony that this expert is about to give has to in some way bear on a material issue in the case. It can't be expert testimony on the speed of a car when both parties have already previously stipulated that the car was going 65 miles an hour. There's no fact and issue there's no material issue to make any determination. It is not going to assist the jury in understanding anything that's complicated because both parties already agreed how fast the car is going. Keep in mind that when you have stipulations, even if you don't bring them into, even if you don't tender them to the bench at the beginning of trial, they're still on the record and you can still use them. So know your stipulations. A lot of times they deal with issues like that and you can really screw someone by using them. So if it's going to assist the jury if it's going to assist the trier of fact to understand the evidence, a witness qualified as an expert by knowledge, skill, experience, training, or education, it's a very, very broad standard, may testify in the form of an opinion or otherwise if, here we go again, requirements. 1, the testimony is based on sufficient facts or data. 2, the testimony is the product of reliable principles and methods. And 3, the witness has applied those principles and methods reliably to the facts in this case. So, going back to Rule 702, when it talks about testimony based on sufficient facts or data in subsection A, it means, did they have enough information to formulate a conclusion? That is it's a toss-up. If you have someone who relies only on the statements of other people, and maybe they just review all these affidavits and everything, If in the context of their job, if that's what they do, then it's sufficient facts or data. If in other words, they're an expert who formulates conclusions based on reviewing other people's statements, then that's sufficient. It's always going to be sufficient in relation to what they're an expert in. Are we clear on that? Clear on that? All right. 2, the testimony is the product of reliable principles and methods. Here we go with reliability again. This is talking about whether the science is trustworthy, whether it's believable, whether it's just hogwash. And the third is whether the witness has applied the principles and methods reliably to the facts in this case. The way that this part would become useful is if you have a witness who says, you have a doctor who says, well, normally I run this test using 5 test tubes and 2 control groups, but this time, I didn't have a great budget, so I only used 3 test tubes and 1 control group. Well, then you have problems. You have problems because they didn't necessarily apply the reliable principles and methods that they normally would to the facts in this particular case. That is Rule 702.